Welcome to the deep dive, where we take complex legal histories and social structures and, well, give you the essential knowledge fast.
And today, we're really diving into something fundamental. The two historical pillars of Hindu inheritance law in India.
That's right, the Mitikshara and the Dayapaga schools.
Exactly. And it's more than just dry legal history. These systems shaped family structures, property control, and crucially had very different impacts on women's rights.
So our mission today is to unpack those differences, right? And also trace how major legal changes like the Hindu Succession Act and especially that big 2005 amendment tried to tackle the gender inequality baked into these old systems.
Precisely. It's a story of tradition meeting reform.
Okay, but first, let's get the lay of the land. Geographically, where did these two systems hold sway?
Right. Good question. Think of a map of India. Middleshar was and still is the dominant system pretty much everywhere else, north, south, west. It's built around this idea of joint family ownership, very intricate rules.
Okay, the vast majority then.
Yes. Dayapaga, on the other hand, was mostly confined to eastern India. Think Bengal, parts of Assam. It was kind of an island, legally speaking.
And you mentioned it was maybe slightly different for women there.
Well, yes, historically. While still patriarchal, Dayapaga did have some elements that arguably gave women certain property rights a bit earlier or more clearly than Mitukshara. It's nuanced, though.
Okay, let's unpack this then, because looking at the sources, you really see this constant tension. On one side, you have these deeply rooted patriarchal traditions.
Which often sidelined women economically.
Exactly. And on the other, you have these major legislative pushes, the Hindu Succession Act in '56, and then the really transformative 2005 amendment trying to force change.
It's that push and pull between tradition and modern equality.
So let's nail down the absolute core difference. Mitikshara versus Dayapaga. What's the defining split when it comes to getting property rights?
Okay, the absolute fundamental difference is when you get the right. Is it at birth or only when someone dies? Mitukshara says, you get the right the moment you're born into the family. It's automatic. They call it unobstructed heritage, aparthibanda daya. Your right isn't blocked by anything.
So just by being born, you're in.
You're in. And this system creates what's called a coparcenary.
Ah, yes, the coparcenary. How did that actually work? Who was in it, traditionally?
Traditionally, it was a male club, male descendants down to 4 generations from the last property holder, and they all held the property jointly.
Okay, jointly. But what did that mean for individual shares?
That's the key. Your share was indeterminate. It wasn't fixed. It would actually fluctuate. Every time a boy was born, the shares got smaller. Every time a copartner died, the shares of the survivors got bigger.
Wow, like a constantly resizing pie.
Exactly. And it meant a copartner, say a son, could actually demand partition slice up the pie even while his father was still alive.
That does sound incredibly complex to manage. Now, let's contrast that. What about Dayapaga?
Dayapaga simplifies things quite a bit. Property rights. They only kick in after the current owner, usually the father, dies.
Ah, so no birthright.
No birthright. It's called obstructed heritage, sapratibandha daya. Your potential right is, well, obstructed until the owner passes away.
So under Dayapaga, the father was the clear owner during his lifetime.
Absolutely. He remained the full individual owner. Much clearer lines of ownership while he was alive.
Which presumably gave him more power over the property.
Precisely. He had much greater testamentary power, the power to leave property in his will. Mitikshara rules generally restricted that for ancestral property.
And you mentioned something about survivorship under Mitikshara. How did that work traditionally?
Right. Survivorship was a core Mitikshara principle. If a copartner died, his share or interest didn't pass down to his own wife or children like we might expect today.
No. Where did it go then?
It essentially merged back into the joint pool, automatically increasing the shares of the surviving copartners.
So if a son died, his widow and kids could be left with nothing from that ancestral share.
Traditionally, yes. That was the harsh reality of survivorship. It kept the property locked within the male line of the joint family.
Ouch. That sounds tough.
It was. Though it's important to note, even before 2005, there were legal tweaks. The idea of a notional partition came in, which could allow certain female heirs, like a widow or daughter if they were Class I heirs, to inherit a share as if a partition happened just before the man's death. It softened the blow somewhat.
Okay, interesting. Let's shift to managing this property then. We hear terms like Hindu joint family, coparcenary, and the Carta. How do they fit together?
Good point. The terms matter. The Hindu joint family is the big umbrella. It includes everyone, males, females, wives, unmarried daughters, everyone living together or related.
So the whole extended family unit?
Basically, yes.
Right.
Now, the Coparcenary, a much smaller group within that family. It's the subset that traditionally dealt only with the ancestral property, and historically it was just those males who got their right by birth under Midikshara.
Got it. Wider family, smaller property-owning core. And the Carta, he's the manager.
He's the head honcho, yes. Usually the senior-most male member. He's the manager, the representative for the whole family. Well, everything. Legal stuff, social duties, finances.
So a powerful position.
Very powerful. The sources call his position sui generis, unique. He's the custodian of the family wealth. But interestingly, not quite an agent just taking orders, and not a trustee in the strict legal sense either. He has broad administrative authority.
But not unlimited power, right? Especially when it came to selling off family property alienation, as the law calls it.
Absolutely not unlimited. This is crucial.
Yeah.
The Carta couldn't just sell joint family property whenever he felt like it. That power was very tightly controlled.
Why the restrictions?
Because the default was that ancestral property was meant to stay in the family, generation after generation. So selling it was a big deal. It could only be done under three specific conditions, laid down centuries ago by the jurist Vishnaneshwara.
Okay, what were those three justifications, the high hurdles he had to clear?
First, legal necessity. This means genuine emergencies at Kale. Think paying off government debts to save the property, defending the family estate in court, or even essential family needs like unavoidable medical costs or funding a necessary marriage ceremony.
Right, things you absolutely have to do to protect the property or the family's existence.
Exactly. Second, for the benefit of the estate. This is a bit broader. It means actions that a reasonable, prudent person would take to improve or preserve the property's value. Maybe selling a rundown property to buy a better one, or investing in improvements.
Makes sense, like good asset management. What's the third?
Third is for indispensable duties, dharmarth. This relates to religious or pious obligations, things considered essential family duties like certain ancestral rites or charitable acts deemed necessary.
So only for necessity, benefit, or religious duty. If the Carta sold property for any other reason...
Then any co-parsoner could challenge that sale in court and potentially have it overturned.
Got it. Now, before we get to the modern reforms, there's one more historical doctrine we have to touch on because it really shows the weight of obligation on sons. The doctrine of pious obligation. What was that about?
Ah, yes. This was a really unique and frankly quite burdensome rule that mixed religion and law. For centuries, it meant that the son, grandson, and even the great-grandson had a religious duty, not just a legal one, to pay off the debts of their deceased father or ancestor.
A religious duty to pay debts. Why religious?
The underlying belief was spiritual. The ancient texts suggested that a man died indebted couldn't attain spiritual salvation, like heaven or liberation. So paying his debts was seen as essential for his soul's peace.
Wow. So the sons were essentially responsible for their father's spiritual well-being through paying his creditors.
That was the idea. It placed this heavy, centuries-old spiritual and financial burden squarely on the male descendants.
Were there any exceptions? What if the debts were, say, from gambling?
Yes, exactly. There was an out. The obligation only applied to what were called vyavaharika debts, legitimate, non-immoral debts. If the debt was avyavaharic, meaning incurred for immoral or illegal purposes like gambling, excessive drinking, or bribery, then the sons were not obligated to pay it.
So you had to pay Dad's business loan to save his soul, but not his poker debts. That really highlights the patriarchal structure, doesn't it? Responsibility flowing down the male line.
Absolutely. It's a stark example.
Yeah.
The good news, of course, is that this doctrine was formally abolished by the Hindu Succession Amendment Act in 2005. Though, like many legal changes, dealing with debts incurred before 2005 can still sometimes get complicated.
Okay, so stepping back, this whole traditional setup, whether Mitikshara or Dayapaga, clearly ended up restricting women's property rights, right?
Unquestionably. That's the broad consensus from legal scholars. Women were mostly entitled to maintenance, or maybe held certain types of property with limited ownership rights, stritan, often linked to their roles as daughters, wives, or widows, rather than having independent, equal rights in the main family property.
Their economic independence just wasn't the priority.
It seems it wasn't structured that way, no.
But then came 2005. That amendment seems like it was designed to be a complete game changer. Tell us about the Hindu Succession Amendment Act, 2005.
It really was a landmark piece of legislation. Its main goal was to tackle that deep-seated gender inequality head-on, specifically within the dominant Mitikshara system.
And how did it do that?
It did it in a very direct way. It
Yeah.
amended Section 6 of the original act to grant daughters the same rights in coparcenary property as sons. And critically, it made them coparceners by birth, just like sons.
By birth, so automatic equal status from the moment they are born.
Exactly. On paper, it put daughters and sons on an absolutely equal footing regarding ancestral property from 2005 onwards.
But I remember reading there was a lot of confusion in the courts afterwards. Like, did the father need to be alive on the date the amendment passed in 2005 for his daughter to get these rights?
Yes, that became a huge point of contention for about 15 years. Different high courts gave conflicting rulings, creating a lot of uncertainty. Some said yes, the father had to be alive. Others said no.
So how is that finally settled?
It was settled definitively by the Supreme Court in 2020 in a very important case called Vinita Sharma v. Rakesh Sharma.
And what did the Supreme Court say? How revolutionary was that ruling?
It was massive. The court clarified unequivocally that a daughter becomes a coparcener by birth. Her right accrues from her birth. It doesn't matter if her father was alive or not on September 9th, 2005, when the amendment came into force.
Wow. So it's truly retroactive in spirit. Her right exists from her birth, regardless of when her father died.
Essentially, yes. The court stated the right is conferred by birth, making the daughter's status inherent. This ruling overturned earlier, more restrictive interpretations, like the Prakash v. Fulavati case.
So provided the property hadn't already been formally partitioned or legally sold before a specific date in 2004.
That's the main caveat, yes, related to finalized transactions before December 2004.
The daughter born into a Midacharva family has the same birthright to ancestral property as a son, period.
Period. And it means she can demand partition just like a son.
Mm.
And if she passes away, her share now goes to her own heirs, her children, her husband, not back to the surviving coparceners via the old survivorship rule. That's gone for daughters too.
And can she manage the property? Can a daughter become the Karta?
Yes, that's another significant development. The Delhi High Court confirmed this in the Mrs. Sujata Sharma v. Sri Manu Gupta case. If she's the eldest member of the coparcenary, a daughter can now step into the role of Karta and manage the joint family property and affairs, breaking that male monopoly.
That's a huge shift. Okay, this legal history is fascinating. Now let's connect it to the real world, the economic impact. The sources you looked at had some actual data comparing outcomes under the two systems, didn't they?
They did, and it's quite revealing. It really underscores why those 2005 reforms were so necessary from an economic justice perspective. Researchers did a comparative analysis looking at inheritance patterns for women in Diapaga versus Midakshara regions before the 2005 changes really took hold.
And what did they find about just the basic chance of a woman inheriting any property at all?
Using statistical methods, like the chi-square test, they found a significant relationship. The numbers from their sample data were stark. In the Diapaga region, studied something like 75% of the women surveyed had inherited property.
Okay, 3/4. What about Midakshara regions?
Only 40%.
Wait, stop there. 40% versus 75%. So under the old laws, purely based on geography and which system applied, a woman in a Diapaga area like Bengal was almost twice as likely to inherit property as a woman in a Midakshara area like Delhi or Mumbai.
Based on that sample data, yes. That's the
Right.
kind of measurable disparity we're talking about, purely stemming from the legal framework.
That's incredible. Did they look at the amount or value of inheritance too?
They did, using a t-test. And again, they found a statistically significant difference in the value of the inheritance received.
How significant, more or less?
Significantly more under Diapaga, according to this data. The average inheritance value for women in the Diapaga sample was roughly double that of women in the Midakshara sample.
Double the value.
Yes. In the simulated figures they used, it was around 500,000 INR mean value under Diapaga, compared to just 250,000 INR in Midakshara. It really quantifies the economic disadvantage baked into that traditional Midakshara model, where women were simply outside the core property-owning group.
Those numbers absolutely drive home why the 2005 amendment wasn't just symbolic, it was economically vital. But okay, the law is now clear on paper. Equal rights from birth. Is it working perfectly in practice? What are the challenges now?
That's the million-dollar question, isn't it? There's still a significant gap between the legal rights enshrined in the law and the lived reality for many women. Well, legal experts and sociologists like Beena Agarwal point out that deeply entrenched patriarchal attitudes and social pressures haven't just vanished. Legal rights can be effectively neutralized on the ground.
You mean things like family pressure on daughters to give up their share? for the sake of keeping the peace or prioritizing brothers?
Exactly that.
Yeah.
Societal norms, the preference for male heirs, the idea that daughters belong to another family after marriage. These cultural factors are powerful and can prevent women from actually claiming or controlling the property they're legally entitled to. There needs to be a shift in mindset alongside the legal changes.
So the law changed, but society hasn't fully caught up.
That seems to be the challenge. The feudal and patriarchal roots run deep, and transforming attitudes takes time, education, and enforcement. Law alone isn't always enough.
Are there any lingering legal complexities, maybe specific situations the courts are still working through with the 2005 amendment?
Where one key thing the Vinita Sharma ruling clarified is that while the right is retroactive, it doesn't invalidate property sales or partitions that were lawfully finalized before December 20, 2004. That date is a cutoff to protect caste transactions.
Okay, so past deals are safe.
Yes, and courts also deal with unique intersections of law and society. For example, there was a case mentioned where the Gujarat High Court ruled that a Hindu daughter didn't lose her inheritance rights under the Hindu Succession Act just because she married a Muslim man. It shows the law striving for neutrality beyond just gender.
That's a powerful point about the law evolving. Okay, let's try and wrap this up. To summarize our deep dive today, we started with these two very different traditional systems. Mythic Shura, dominant across most of India, based on birthright, joint ownership, and the fluctuating shares of the Coparcenary.
And Dayahaga, mainly in the East, based on inheritance only upon death, giving the owner more control during his lifetime.
We saw data suggesting that historically, Mythic Shura led to significantly fewer women inheriting and inheriting less value. Then came the massive shift, the 2005 Hindu Succession Amendment Act.
Which fundamentally altered Medikshara law, making daughters equal co-parceners by birth, same status as sons.
And that principle was cemented definitively by the Supreme Court in 2020's Vinita Sharma ruling, confirming the right applies from birth, regardless of when the father died.
Absolutely. The law now clearly mandates gender equality and ancestral property under Medikshara. It overturns centuries of male precedents and the old survivorship rules for daughters' shares.
But as you said, the final hurdle is practice. Achieving true equality on the ground means overcoming those stubborn cultural barriers and social pressures that still prevent many women from fully realizing their legal rights.
That's the ongoing struggle bridging the gap between legal entitlement and actual control over resources.
Which leaves us with a final thought for you, our listeners, to ponder. We saw that historical data suggesting women under the traditionally less equal Mitakshara system inherited less often and less value than under Dayapraka. Now, the 2020 ruling has established definitive legal equality across the board, applying retrospectively. So the question is, how quickly do you think that centuries-old measurable economic disparity between regions rooted in these old laws will actually disappear in practice on the ground? How long until reality fully catches up with the law?